gostaria também de agradecer, né, esse espaço, com bastante alegria que eu acompanho mesmo com a Cristina, que é uma pessoa que eu conheço, respeito, gosto, primeira vez que a gente está juntas, né, assim, então, muito bom. O meu texto está em inglês e eu, então, vou lê-lo também, tá? Só para problematizar, colocar o problema, né? Ele surge de dois artigos que eu li, um do Gerald Gauss, quer dizer, ele está dialogando então com dois autores, né? Tentando fazer uma crítica a uma análise de dois autores. Um de Gerald Gauss, que é um autor que se coloca na terceira geração de rawlsianos, de intérpretes de Rawls, e que estabelece a ideia que a justiça política, ela justiça distributiva. A justiça distributiva tem que estar contida em algo como a concepção de bem, e a justiça política, então, ela, sempre que ela entra na esfera da justiça distributiva, ela já está entrando numa esfera que não dá para se legitimar, né, a questão da legitimidade que se coloca. Então, com esse texto e com essa, depois eu vou colocar ao longo do texto, né, no qual ele prepara essa cisão, e juntamente com um outro artigo que eu encontrei na literatura norte-americana, que fala Harming the Poor Through Social Rights Litigation, Lessons from Brazil. Esse professor aqui da University of Warwick, Otávio Luiz Mota Ferraz, no qual ele vai acabar dizendo que o fato de a gente ter Social Rights Litigation no Brasil acaba afetando os pobres de forma negativa, né? E esse é um dos poucos artigos em inglês assim, publicados em um desses journals grandes, no qual se fala sobre o Brasil, e é isso que ele afirma. E, no fim, a conclusão dele é que, então, o judiciário tem que parar de falar sobre direitos sociais. Então, eu vou estar dialogando um pouco com esses dois autores, eles fazem o pano de fundo. So, I'll start I did a brief introduction for the non-Portuguese speakers. I just was giving a brief introduction to my work, but now I will continue in the English paper. So, empirical work on legal enforcement of social rights has recently begun to... first I would like to say just one more little thing about my title, because I won't really... I'll just say a little bit about the non-instrumentality argument for the constitutionalization of social rights, because when I started talking about constitutional courts, political and distributive justice, Andrew Lister from Queen's University, he asked me if there was a non-instrumental or a dimension to my work. So in a way, I still attempt to respond or to think about his question. So I will arrive at that in the end. But for the most part, I'll be talking about constitutional courts, political and distributive justice in a Rawlsian framework. So, empirical work on legal enforcement of social rights has recently begun to focus on broad approaches that consider relations between social rights litigation and advances in social transformation. The results so far haven't been promising. From regarding successful cases in South African legal jurisprudence as exceptions, to arguing that judicialization of socio-economic rights has given more power to judiciaries but not necessarily resulted in social transformations, the question of have courts brought about social change has mostly been answered negatively. Regarding the effects of such adjudication in Brazil, it has been argued that considering litigation in health rights, legal enforcement has actually harmed the poor, and that social rights should be taken away from Brazilian courts. So this is this paper that I was referring to. In this background, the principal aim of my paper is to argue that even though the results have been negative regarding the consequences that so far have been shown in regards to the benefits to the poor, this solely cannot support the conclusion that social rights should be excluded from the Constitution or from adjudication. Much attention has been given to the consequences of litigation, and little or less attention has been given to the quality of judicial reasoning, the limits it should attend to, and the role that it should play in democratic societies. I'll argue that the work that stems from on-ground effectiveness of social rights litigation plays an important role in criticizing the protagonism of courts in new democracies, as it shows important limitations in its capacity to promote progressive change, social changes that are, for example, supported by a specific theory of distributive justice. But they point out as well that unchecked, courts can actually be harmful, and as we know, this is one of the main issues. How can you check? I mean, there's no way to do like another review of court decisions, constitutional court decisions. But this is insufficient to provide an answer that demands the non-justiciability of all social rights. Such a response can also be harmful, as it may close the door to important cases that courts actually have the capacity to push for progress. Here, I mean to look at these questions by relying on Rawls's view on justiciability. The motivation for considering the Rawlsian framework does not aim at arguing that these practices should be evaluated solely by his theory, but it does consider that Rawls's view on such matters can build stronger arguments to critically evaluate constitutional court decision-making, and also can, on the other hand, help elucidate some contended aspects of the theory of justice as fairness. This paper will be divided into the following sections. I have some conceptual clarifications that address the idea of justiciability, judicialization, judicial review, and juristocracy. Then I'll give a brief example of a scenario of judicialization in Brazil, focusing on health rights litigation, support the idea of justiciability in a Rawlsian framework, and I'll just, afterwards, in the end, I'll give some considerations on the relation of political justice and distributive justice. There are many terms, such as judicialization, judicial review, justiciability, juristocracy, that relate to the constitutionalization of social rights and the role that constitutional courts have assumed in the political realm. All of these terms are connected to the practice of judicialization, which can be loosely defined as the transfer of power from representative institutions to judiciaries. Judicialization can also be considered an umbrella term that relates to three interrelated processes: the judicialization of social relations, judicialization from below, with courts contemplating mostly procedural processes, classic liberties, and juristocracy, where core political controversies are decided that divide and define whole politics. So this is Hirsch and towards juristocracy. This is the way that he defines judicialization. But we are talking about here justiciability, which concerns some different matters. Whereas judicial review is a legal procedure that permits courts to review the constitutional validity of legislative acts. With it, judicial review, comes the idea of justiciability worry, which means that one should worry about the suitability of a norm or a class of norms for judicial application. Basically, the justiciability debate has differentiated two possible spheres of questioning. Is it appropriate for courts to adjudicate these rights? How far should adjudication go? Empirical work looks at a different question, the efficacy of justiciability. Regarding social rights in new democracies, the answer seems to point out to the non-efficacy of social rights litigation, and in Brazil to the harmful aspects that it can have. How can this empirical work inform the theoretical debate? Should the encouragement of justiciability depend on the empirical data? Ferraz will argue that this is the case since the consequences of justiciability for him are strongly context-dependent. In this proposal, I would suggest that efficiency does have a role to play, but as the requirement of our political justice in the Constitution. Casting efficiency solely in the former framing, that is, considering the empirical results, such as judicialization of health rights, is problematic due to the non-differentiation of which rights should be the object of social rights litigation. The lack of scrutiny can, in fact, also be harmful. The latter, that is, when one considers efficacy as an important aspect of political justice, may provide a strong basis for questioning social rights litigation, not only in regards to justiciability, but as claims that, if unmet, provide foundation for questioning the legitimacy of the regime. Where the action is, this is a kind of joke with the Cohen's paper. So, judicialization in Brazil. Judicialization in Brazil results from three main reasons: constitutionalization in 1988, the inclusion of topics from social rights to environmental guarantees in the Constitution, and a kind of constitutionality control established. Brazil's constitutional court can be described as an active court due to its ample interference in other branches. Perhaps one of the cases that demonstrates this the best, or not the best, or one of the first cases, was a ruling that established that legislative seat belongs to the party and not to the person who won the election. This was a decision for Clodovil when he was a congressman. He lost his seat at Congress. He decided to change party. He said that he had a fair cause because he suffered discrimination because he was gay, and from his party, and the Constitutional Court overruled all of the previous decisions, saying that the chair was not his, it was from the party. So in this case, the court enforced an understanding of party fidelity and overruled the previous decision. That is exactly what I was telling. Recently, the Brazilian Constitutional Court has decided regarding health rights litigation which drugs should be provided. This debate was triggered by health rights suits flooding the courts and burdening the unified health system with significant costs in the past 15 years. The main problem is the meaning of health to right isn't clear, and states have had, due to judicial decision, to pay many high-cost drugs and haven't been authorized by the National List of Medicines. An aspect of this deliberation that is worth pointing out to is that one conclusion that was reached was that the criteria should be established in two dimensions: high cost and medication outside the official list. I found it interesting to bring like an idea of one justice, what he said, in favor of high cost as long as the patient does not have the financial conditions. But if his family has, he can just sue them for it. So he just put some kind of like familiar solidarity as from the justice to the society. Apart from the particularities that arise from such case, such as the idea of mandatory familiar solidarity in case of high-cost medicines, it has been shown that litigation of health rights, health rights is really interesting because it has been one even of the issues that it's in political sphere right now. We have one of our, one of the candidates that's trying to be president. He's been criticized for actually saying that the judicial courts are draining money from communities by these decisions, and he's been like heavily criticized as, oh, you're against the law, you're against, but he's actually saying, you know, everybody should stick to what they are responsible to. Apart from the particularities that arise from such case, such as the idea of mandatory, it has been shown that this litigation of health rights in Brazil has not benefited the poor due to the difficulty in the access to the judicial system, and therefore has not guaranteed a minimum to the poor, but a maximum to the well-off, in a pattern that has been described as maximum health attention. So this is not only in Brazil. Usually this is one of the main criticisms that is traced to the justiciability of social rights. It's in the literature from abroad as well. Reasons that support in this case the non-judiciability claim are based on the argument that the only thing that can effectively bring about social transformation would be something like a strong egalitarian ethos, and courts being incapable of eradicating inequalities and poverties. In this argument, we recognize the claim that can be defined as less justice. That is, the idea that courts are likely to make mistakes, leaving us with less justice rather than more. So after, I will show how this idea of less, 5 minutes? I will try to show how this idea of less justice is one of the concerns that Rawls has when he talks about constitutional essentials. Rawls's view of justiciability. Justiciability of social rights, therefore, can be considered in 3 dimensions: appropriateness, scrutiny, and effectiveness. John Rawls believes that justiciability makes a difference that counts in deciding which requirements of justice as fairness should and which should not be classified as constitutional essentials. To consider the second sphere of justiciability in Rawls's theory, not all requirements of justice, that is, not all substantial demands of the 2 principles belong in constitutional law. Only constitutional essentials, which exclude distributional norms of the second principle, but should still be considered requirements of justice. Therefore, and I am, this is Frank Michelman's position, which I am accepting. There is a legitimacy justice gap that can be noted. This is due to the fact that legitimacy regards the justification of the coercive exercise of democratic power, which can be morally justified only as long as it conforms to a proper set of constitutional essentials. Whereas the second principle's distributional demand regards the norms that political practice must strive in order to satisfy justice. In the citation below, it's possible to verify Rawls's standing in regards to this idea. Whether the constitutional essentials covering the basic freedoms are satisfied is more or less visible on the face of constitutional arrangements and how these can be seen to work in practice. But whether the aims of the principle covering social and economic equalities are realized is far more difficult to ascertain. These matters are nearly always open to wide differences in reasonable opinion. They rest on complicated inferences and intuitive judgments that require us to assess complex social and economic information about topics poorly understood. Thus, we can expect more agreement about whether the principles for the basic rights and liberties are realized than about whether the principles for social and economic justice are realized. This is not a difference about what are the correct principles, but simply a difference in the difficulty of seeing whether the principles are achieved. Yet, it should be noted that fair value and social minimum are part of the constitutional essentials. What does fair value mean? Fair value is of political liberties means that everyone, regardless of social and economic position, has a fair opportunity to hold office and influence the outcome of political decisions. Social minimum means you should provide for the satisfaction of citizens' basic material needs insofar as required to enable them to take effective part in political and social life. But don't they suffer the same obscurity? So Michael will invite us to think of something like an urgency factor, which is unrelated to justiciability, but can help understand why fair value and distributional assurances are part of the constitutional essentials. What is urgency in relation to liberal legitimacy? In Rawls's view, a graphic guarantee that everyone shall enjoy the fair value of political liberties is in fact urgently required for the legitimacy of any system for the exercise of political power, and likewise, apparently, for the assurance that everyone's basic needs are met. The urgency factor that applies to assurances regarding the basic liberties also apply to these 2 distributional assurances. That observation argues for giving both of them expression in the constitutional law, even if at the cost of involving courts in decisions of a kind which they are not especially well suited. The constitutional essentials bear the full weight of legitimacy, which means that its features have to be relatively discernible and to enable some kind of compliancy check. There are 2 things going on Rawls's discussion of constitutional essentials. It plays 2 roles. On one hand, which parts of constitutional law have to meet Rawls's normative standard in order to be legitimate? On the other hand, assuming that the judiciary will be charged with overturning constitutional law, it determines the principles that get written in the Constitution for courts to enforce. If one is worried with the competency of the judiciary to make complex social scientific judgments, the difference principle is not constitutional because courts are likely to make mistakes, leaving us with less justice, less than more. So this is the less justice worry. On the other hand, taking the difference principle as a constitutional essential, one can recognize that citizens just disagree in big ways on how to satisfy this principle. This disagreement is on the legitimacy of law, on what can be considered less perceived legitimacy. It's not really related to the judicial review. It is crucial to distinguish between these two dimensions, what the standard of legitimacy is and whether courts should be the ones to overrule unconstitutional law. For example, one can think that the difference principle is part of the legitimacy standard, but that the courts just should not be enforcing it. Or that it should not be part of the constitutional essentials, but that courts should enforce it. In this case, one could think of something like a weak standard of legitimacy that doesn't include the difference principle, but courts would be able to enforce an egalitarian concern. It is by deepening the context of less perceived legitimacy that a group of interpreters of Rawls, they call themselves, well, I've read this in Kevin Vallier's works, so third generation of interpreters, they have made a case for the need to uncouple distributive justice from political justice by claiming that the tie between political and specific accounts of distributive justice under contemporary conditions of moral disagreement must be uncoupled from one's conviction about the best account of distributive justice. And this is all based on their interpretation of legitimacy on Rawls's later writings. Such questioning of particular, so this is one of the problems, I think, of this reading, because we can see that sufficientarian accounts of justice have been fueled. There are many papers and books right now trying to give a sufficientarian account of justice, probably because one of the diagnoses that the egalitarian ethos is shrinking all over the world. So in that case, it's almost like this, let's stick to sufficientarianism because at least it guarantees this minimum, right? So I'm just, my reading is that this interpretation, it ended up fueling these sufficientarian accounts of justice that began with Frankfurt's work, but we can see that they are like one of the, in the state of the art right now. There are like many books coming out on this issue today. So Rawlsian distributive justice, going beyond the difference principle. Sufficiency principles do not favor the elimination of inequality as egalitarian principles, benefiting the less well-off as more important than the better-off. Instead, they insist that when evaluating different distributions, it's important to see if people have enough. It has a huge problem of threshold here, and I'm taking Paula Cassal's influential article, Public on Ethics, where she says the problem of sufficientarianism. And Frankfurt's work has in Rawls's theory one of the main targets of contemporary egalitarianism. But Rawls is well aware, as the sufficientarians, about the need to eliminate deprivation. Accordingly, it is possible to claim that Rawls's theory provides a sufficientarian account of justice in the requirements that should be conjoined with the difference principles, such as the social minimum, justice-saving principle, liberty principle. In Rawls' later work becomes a principle of sufficient and not maximum liberty, leaving room for implementing other principles, even when it takes priority over them. This is not only an interpretation of Paula Cassal, but we can see the Martha Nussbaum, and recently she says that from economic justice, from theory to political liberalism, it's also possible to identify in Rawls's later work, actually, a more radical insight than the earlier. In earlier work, Rawls tends to separate liberty from economic questions, but in political liberalism, he recognized that liberty may have economic prerequisites. Furthermore, along with the difference principle, principles such as fair value, fair equality of opportunities are also constitutive of Rawls's conception of distributive justice. These, one may add, are principles that actually may be threatened by too much inequality. So there's also a paper from a professor of UPenn that tries to show this. But anyways, why am I referring to all of these things? Just to say that distributive justice in John Rawls' work goes way beyond the difference principle. The complex design of distributive justice goes beyond and shows an overlap of the political conception with aspects of distributive justice above mentioned, which points out to the problematic answer that Rawls gives when he just uncouples both. One has to wonder what the political conception of justice gets left with when you leave all of these parts behind. The claim from taking social rights away from courts articulates the less justice dimension, as well as the claim of uncoupling distributive justice from political justice has less legitimacy, perceived legitimacy dimensions. So for me, both authors, they just have a one-sided interpretation in their conclusions regarding this path, either of guaranteeing social rights or the idea that distributive justice has become some kind of conception of good. One could find some middle ground actually in articulating this double role of constitutional essentials. Do I have a minute or finish?
Yes.
So in 1 minute, I'll just in the final remarks, I tried to address this question that Andrew Lister made to me, if there's an instrumental or not, or non-instrumental. So I'll just ask you, share with you the questions that he asked me. Should constitutional social rights be decided upon the basis of what procedure is most likely to give us just policies? If libertarians took over and eliminated welfare programs and then constitutionalized the absence of these programs, what are the objections that we can make? Are there any non-instrumental objections? So what made me start thinking about these questions is actually how close it is to reality and what can you actually say to our friend who just decides that meritocracy resolves it all. French philosopher Cécile Fabre, in Social Rights Under the Constitutional, recalls the following assumption that are shared by democratic and distributive justice theorists. We all have fundamental interests in a decent life. Autonomy and well-being are two privileged conditions for having this decent life. Our interest in having a decent life and our interest in autonomy and well-being matter as much as other people's. We have a moral equal right against others that they respect these interests. So her conclusion is that individuals have social rights to an adequate minimum, and those rights must be entrenched in the constitution of a democratic state. So she realizes that the second assumption is more controversial because most of then she says Nagel, Rawls, Dworkin, most of these authors did not thematize directly the entrenchment of these rights. And of course, she sees the difference between the Anglo-American jurisprudence and the European. So she considers social rights to adequate minimum income, housing and health are not part of the concept of democracy, so that constitutionalizing them amounts to upholding social rights at the expense of democracy, that they are, in a limited number of cases, necessary conditions for democracy's function and survival, and that in those cases, constitutionalizing them is a true value of democracy, even though if it constrains the democratic majority. That the right to education is a defining feature of the concept of democracy and a necessary condition for its function and survival. Then I'll stop here, not to disrespect my time. And can I? Okay, it's just 1 page. Because then, of course, we come to the question of the instrumentalization of democracy. So I found it also interesting to if one could ask then, what about democracy then? If you connect social rights with democracy, what about democracy? Is there still the question of instrumentality of democracy? So then I just went then to start thinking about these questions to Elizabeth Anderson, who has argued that non-instrumental values can be conditional or instrumental. For example, democratic participation would make no sense if it didn't achieve the ends to which it was instituted. Yet, in virtue of the instrumental value, it acquires non-instrumental value. As something that many citizens rightly value of the life they value non-instrumentally. Even if a dictatorship gives people what they want, democratic citizens prefer to govern themselves. Anderson aligns her claims with the democratic thinking of John Stuart Mill and Dewey, who hold democracy as a way of life defined by membership, reciprocal cooperation, mutual respect, and sympathy. In this vein, it's also noteworthy that Gauss, in a paper that I find very interesting, when he tries to show the convergence of rights between Mill and Rawls, he argues for something like a common psychology shared by both authors. Which is this common psychology? For them, they have a democratic personality, a natural sentiment of unity and fellow feeling, with social relations being considered a good, not merely instrumental, as expressions of deep psychological craving, fellow feeling. And I was hearing to Marta this morning, I don't know if how your talk would relate. So, the defense of non-instrumental reasons for social rights seems a possibility by following this path. I'll just finish with Philippe Vaparet, because even if you don't want to go to the non-instrumental path, he, in the paper, he asks us to offer a compelling instrumental view of the difference principle as incorporated in comprehensive moral doctrine by recalling that although it's focused on institutions, those institutions are powerful influence on individual motivation. The difference principle permits the design of institutions that actually foster and methods of solidarity, work, patriotism, not because there's something intrinsic good of this life, but because of its instrumental value in the service of boosting the lifelong prospects of the incumbents of society's worst position. Thank you, I'm sorry for taking me.